Hello, it's Phillip Taylor speaking from Richmond Green Chambers, and this morning I'm looking at a book which is an exciting book for me from the publishers Edward Elgar, an independent family publishers. They produce a lot of academic work, and this is a particularly important one in the area of competition law, and it's written by our old friend Richard Whish and Christopher Townley. It's called New Competition Jurisdictions, with the subtitle Shaping Policies and Building Institutions. That's the book. We'll have a look at it in a minute. I think it's an excellent book, I have to say, and a great leader book, if you like, for Elgar. What we say is competition law in at least 100 countries. It's the general title of what this book's about. You might be surprised, or perhaps you might not be, to learn via this new book from Elgar that there are now more than 100 systems of competition law worldwide, mainly as a result of various political and economic changes that have taken place in the last 20 years. So the new competition jurisdictions, by the way, include such countries as South Africa, Brazil, and a number of other Latin American countries, including Central America. Some have had to implement competition law systems as a condition for acquiring international trade agreements or international loans, mainly the latter. Also, the UN Conference on Trade Development, UNCTAD, I'm not going to try and say how else you pronounce it, has been advocating competition legislation for some time, and of course the long-term aim will always be to have some form of standardisation. For lawyers, therefore, these developments are of fairly major significance, not only to those who specialise in competition law, but practitioners as well. The proliferation of new competition jurisdictions begs a number of questions, including those that ask whether there can or should be standardisation, as I mentioned before, of the law. Co-editors Whish and Townley, each leading authorities in competition law, expressed doubts that a one-size-fits-all approach is appropriate or reasonable, since different countries and different types of economy have their own susceptibilities and peculiarities. And being a devil's advocate, think of the euro at this point. So what is the right approach or approaches? That was the problem and the topic discussed and researched as the result of the 6th conference of ASCOLA, the Academic Society for Competition Law, which challenged a group of young academics from a variety of universities and institutes worldwide to produce ideas and eventually papers on how new competition law systems can be made more effective. And this book incorporates those thoughtful, erudite and certainly original papers. There's the book, there's the back. It's not a particularly long book. You've got lots of footnotes at the side there, which are very useful to find. You've got a little index at the back, 350 pages long, the book itself, and you've got a lot of very detailed information. There are some nice tables of cases, legal tables and so forth from the various countries. Do look at the actual abbreviations, which I think you will also find helpful. Also, it's got a list of the contributors. I'm delighted that Elgar have produced this book. I think it's a great step forward for us, both within the jurisprudence of competition law itself, but in a much more general sense. And we've got to start looking at it in the 21st century. So thank you to all concerned. Bye-bye.